the Legal Corner podcast series. Welcome to today's episode of The Legal Corner, a podcast which covers a variety of legal issues to keep you informed. Hosted by attorney at law Colin Dinoon and communications specialist Leonardo Torres.
Thank you for joining us for another episode of the Legal Corner podcast series. I am your host, Colin Dinoon, attorney at law, and I'm joined by my co-host, Mr. Leonardo Torres, who is our resident communication specialist. Good day to you, Leonardo.
Good day, Colin. How are you doing today?
I am great, excited. We are getting another episode out of the way. Those numbers are climbing. We are now at episode number 9.
Correct. Correct.
So it's really an excellent thing. How about you? How are you doing today?
Not bad at all. A very hectic day today, but I really wanted to be here for today's episode. It's on a very interesting topic. And I think I'll let you now introduce the guest. We're very happy to have him.
Excellent. Well, in today's episode, we'll be looking at the topic of protecting your intellectual property. With the advent of the COVID-19 pandemic, an increasing amount of everyday transactions are being conducted online. Additionally, persons who create content are increasingly looking to the digital space for avenues through which they can connect with and entertain their audiences. This makes it all the more important for persons to be aware of the rights that a content creator has to their work and what remedies are available to them if their rights are infringed upon. Joining us on the show today to provide some insight is Mr. Jason Nathu. Jason Nathu is an attorney at law with over 15 years post-qualification experience in Trinidad and Tobago. He is a full-time tutor at the Hugh Wooding Law School in the General Legal Aid Clinic and the supervising tutor of the law school's Human Rights Law Clinic and Innovation, Technology and Entrepreneurial Clinic. His primary areas of practice are civil litigation, intellectual property, family law, discrimination law, and the administration of estates. He is currently an academic member of the International Trademark Association and a member of the advisory board of Street Law Caribbean. And he is currently an advisor to the Photographers Guild of Trinidad and Tobago. He holds a Bachelor of Arts in History from the University of the West Indies, a Bachelor of Laws from the University of the West Indies, a Legal Education Certificate from the Council of Legal Education, and a Masters of Law in Intellectual Property from the University of London. Good day to you, Jason, and welcome to the Legal Corner.
Hi, Colin. Hi, Leonardo. Very lovely to be here today. And congratulations on the podcast. It's always fantastic to see different avenues to the public to get legal content and legal information. So kudos to you guys on this project.
Thank you so much, Jason. We are so happy to have you today. We want to get right into our interesting topic, and I know you have a wealth of information that you're going to be sharing with us. So I want to ask you straight out, what would you say is intellectual property?
Sure. So when we talk about intellectual property, we are referring to creations of the mind. This can include inventions, literary and artistic works, designs, and symbols, which are the names or images used in commerce, such as logos or slogans. So intellectual property, we need to understand, is something that is protected by law, which enable people to earn recognition or financial benefit from what they invent or what they create.
That's interesting that you mentioned protected by law. Is intellectual property the same as copyright?
That's a very interesting question, Colin. So intellectual property is a very general term that comprises several different types. Copyright is one type of intellectual property, but there are others. For example, trademarks, patents, industrial designs, geographic indications, and trade secrets. And each protects something different. I could give you a little general rundown if you would like.
Sure.
Okay, so when we talk about copyright, we talk about works that are literary, artistic, photographic, etc. Of course, there's a much wider ambit, but things like computer software, anything that's in some sort of tangible form that is the express creation of someone's intellect is protected by copyright. Now, when we talk about trademarks refer to distinguishing symbols that are capable of identifying someone's business from that of their competitors. So you might have a business name, you might have a business logo, you might have a business slogan. A patent is a process that is new, that has an inventive step, that involves industrial applicability. And sometimes you might see patents in medication, vaccines, for example, certain types of equipment, all right, that possess all three of those things, but in the industrial applicability. Industrial designs, on the other hand, is where you have something that is aesthetic. So you have maybe jewelry that has some sort of three-dimensional form, maybe a carnival costume might take some sort of aesthetic design, all right, that is capable of being registered as an industrial design. And then, of course, there are other types of IP as well, geographic indications where a particular brand is capable of being registered on the basis of its geographic origin. For example, we know of champagne from France. In the Caribbean, we there are brands like Grand River chocolate, Grand River cocoa. In Trinidad and Tobago, Moruga Hill rice is another Trinidad and Tobago brand that should be registered as a geographic indication indicating that its quality is from Trinidad and Tobago. There's also trade secrets. One of the best examples of trade secrets that we may know of is Angostura bitters. All right, that's a protected secret and confidential information. So all of these are various types of intellectual property.
So intellectual property then would be the overarching theme, and then we have these sub-elements that make up intellectual property.
Yeah, so intellectual property is a collective term for this category of property. Why is it called property? Because it can be bought, it can be sold, it can be assigned, it can be licensed, just like any physical property. But it's all relating to a creation of the intellect or creation of the mind, and there are different types of intellectual property, of which copyright is one.
All right. Now, as we get more into the topic of intellectual property, I like how the conversation is going. Now, in terms of digital content itself, what aspects of that would be considered intellectual property?
Okay, so when we talk about digital content, digital content comprises so many different elements. Sometimes you have to dissect a product into salami slices, and you find different elements. So let's say the Legal Corner podcast, the podcast as a name, all right? Perhaps that name may be capable of being registered as a trademark. Maybe you all might have a logo. I've seen that picture with Colin and Leonardo and a little logo. The logo itself may be something that may be registered as a trademark. You might have a theme song or theme music, certainly protected by copyright if it's an original creation. Maybe you would have background music sometimes to a podcast, or if you're doing a video on YouTube, people very often license background music or download um, background music that they are able to legally use because of copyright claims. If you are a video creator, for example, your footage, the actual talking head footage of a person speaking to a camera, well, that's their intellectual property. In that is what they are recording. So that intellectual property presumably will belong to the author. But then you may have B-roll that is superimposed upon the main A-roll footage, background graphics or background videos, etc. Also separate elements of intellectual property. So you see, you have all these various elements that now come to create one digital asset for a creator, and all or each of these elements comprise various aspects of intellectual property.
All right. So now that we have gotten an understanding of digital content and the aspects of it that are considered intellectual property, now for the content creator who might be listening today, who is interested in this topic and getting his property protected, how would you advise that they can go about protecting their work?
Well, of course, I am a lawyer, so the first thing I would say is make sure you get proper legal advice. But there are a few things that I think the digital creator should know. The first is, when it comes to intellectual property, there are certain types of intellectual property that are registered, and there are certain types of intellectual property that gain protection simply by virtue of their creation. So, for example, copyright. If you were to write a book, or you were to write a script for your podcast or your YouTube video, you were to take a photograph, you were to create a sculpture, you were to paint a painting, all right, that exists simply by virtue of creation. Once you can prove that you are the original author of that work, maybe you have an early draft of that work. People used to say what's called poor man's copyright. You send a copy in the mail to yourself. Just sending a copy in the mail to yourself does not protect the work in itself, but what you are doing is you're creating something with a stamp from the post office that proves that you are the author of this work at a certain date. Now there's computer software to help with that. So the files on your computer that can prove that your drafts were created at this particular date or that particular time. If you want to be extra vigilant, you could even go as far as to have a statutory declaration drafted where you declare that you created this version of the work on this particular date. All right. So with regard to copyright, you just need to be able to prove that you created this work and you have your early drafts and your early versions. When it comes to trademarks, however, you really should register your trademark. And there is a central registry in Trinidad and Tobago, the Intellectual Property Office, where you can register your trademark. Now, your trademark must be distinctive of the good or service that you want to register it for. And when we talk about distinctive, say, for example, computers, an apple, or the fruit, an apple, is not necessarily something that is indicative of a computer. So that's how the Apple Computer Company has managed to register a trademark where the apple is distinctive of computers, because it wouldn't ordinarily be associated with computers in any other context. So you can register your trademark and you gain protection for a certain period of time, and then you renew upon the expiration of your trademark. Similarly, with industrial designs, you register your industrial designs, you register your patents.
How long is that trademark valid for after registration before it needs to be renewed?
So the trademark is registered initially for a period of 10 years, and then you can apply for a renewal of that trademark.
Okay, now tell us a bit about the Copyright Act and what role does it play in protecting the rights of creatives?
Okay, so the Copyright Act of Trinidad and Tobago is the legislation that guides copyright, and it's important to know what you can and what you cannot do, what copyright protects and what it does not protect against. So I think the first place to start is with Section 8 of the Copyright Act, which identifies what is protected under our legislation. So the Copyright Act protects, well, when I say protects, it gives an exclusive right to the author of a particular work to authorize or prohibit reproduction, translation, adaptation, arrangement, or transformation, public distribution, rental or public lending, importation of copies, public display, public performance, broadcasting, or any other communication to the public. So, by virtue of the Copyright Act, the author, the original creator of a particular product, which the legislation calls a work, has the exclusive right to do any of these things. So if it is that someone else, some third party, is found to be doing any one of these things, displaying to the public, broadcasting, importing a copy, reproducing, then there's some sort of redress under the Copyright Act for the original author of the work to bring an action for infringements.
From your experience, would you say that creatives normally assert their legal rights when they see their works being utilized without their permission, or is it that persons may be hesitant?
Well, Colin, that's why I think forums like these are very important, this podcast, by giving this type of information to creators, etc. I think a lot of people embark on creating work without considering the implications, the intellectual property implications. I think now people are a little bit more business savvy and people know that, all right, before I embark on writing a book or creating a podcast or a YouTube channel, where I have relationships with third parties, etc., that I should have some sort of contract in place. So, particularly if you have several persons working on a project together, maybe you might have employees. People now tend to have contracts in place, confidentiality agreements in place. If you think in the example of a restaurant where a particular dish is a signature dish on the menu, maybe the restaurant would have some sort of confidentiality agreement with the employees that remains the IP of the restaurant, that signature dish. And if the person were to leave the employ of that restaurant, that they would not be able to just recreate it anywhere else within a certain time, a certain period of time, for example. So I think people have certainly become more business savvy in ensuring that they have contracts in place. But the reality is very often we do hear that either there was no contract in place, maybe there might have been some sort of very some sort of oral agreement that was not properly developed, so that the terms and the scope is not very clear after some infringement or some sort of incident has occurred. Or you may find that there was no contract at all, and now there are disputes where people are now left to seek legal advice in terms of how to resolve them. At Carnival time, we just came out of our Taste of Carnival for Trinidad and Tobago for 2022, but we always hear about event promoters, certain parties, and if you think about intellectual property ramifications for the artists, for the promoter, for the production team generally, I think people have gotten much more business savvy in terms of contracts there. But very often you hear that there was no contract in place and it turns out into a fiasco when it's time to for people to claim their rights.
Now tell us a bit about a scenario where you would have encountered in which persons' intellectual property rights were breached and they obtained redress from the court.
Okay, so in Trinidad and Tobago, there have not been very many matters that have advanced to the courts in terms of copyright. There are several examples in the realm of trademarks where, because again, because trademark is something that you register, um, you are able to bring an action on the basis of the registered trademark. So there have been quite a few trademark cases in the courts. There have not been very many in terms of copyright. Very often you find in these types of disputes, there is settlement before final determination or final judgment. There have been very few intellectual property matters in Trinidad and Tobago where the matter went all the way to judgment and determination of a quantum of damages by the judge. There are a couple active matters that are before the court now that there may be judgments that were rendered, but assessment of damages is still in progress.
Now, as we talk about assessment of damages, now we know as it pertains to these types of matters or any legal matter on a whole, attorney fees and legal fees are not cheap, and sometimes people will calculate these things before they get to that point of what could be the compensation. As it pertains to any particular element of intellectual property, from your experience, or from what you have done in terms of research and these types of matters, how does the court arrive at an amount to compensate the claimant once it has been adjudicated in the claimant's favor?
So again, in Trinidad and Tobago, there's very little precedent to guide in terms of what the court should take into consideration. I think that once that precedent has been created, there would be a set formula to use. But certainly it depends on the evidence. So what evidence would the claimant put forward that has what has the damage cost the claimant? How do you quantify that cost? Is it a loss of reputation? Is it a loss of potential earnings for the same work? So say, for example, the work was infringed. Is it now by the work, because the work was infringed, that the claimant can no longer sell that work or make money from that work? How do you value that? What evidence have you put before the courts to value that your commercial relationships, etc.? What type of price were you attracting for your works previously before this work was actually infringed? All right. When it comes to assessment of damages in any matter, not just in an intellectual property matter, there are two general categories of damages. There are general damages and there are special damages. So there might be certain expenses that the claimant would have expended money on that he or she can certainly list and ask for recovery of those figures, which would be special damages. So, if they spent a certain amount of money trying to negotiate or settle the matter, or trying to alleviate the situation, there may be receipts, etc., that could be listed as special damages. But when it comes to general damages, because we don't have precedent of our local courts. Once the court weighs that evidence that I was just talking about, the court is going to have to look at similar matters in other Commonwealth jurisdictions, particularly the UK, Canada, Australia, Singapore, India, to arrive at a formulation in terms of how it's supposed to be quantified.
All right. And what about defenses? What would you say are some of the defenses that are available in intellectual property claims?
Okay. So when we talk about defenses to intellectual property claims, so again, intellectual property is such a broad area. So you're talking about several different types of intellectual property, and perhaps different types of intellectual property may have different defenses. So in terms of copyright, for example, if someone were making a recording for their own personal use, someone were making a recording specifically for educational use, but educational use being maybe using an extract from a textbook in a classroom environment, not reproducing and photocopying an entire textbook, making it available to their class. All right, that may be accepted. If, for example, a newspaper or a television news broadcast showed an image that may be subject to copyright in the course of news reporting, that would be an acceptable defense as well. And generally, those are the types of what we would call fair use aspects of copyright defenses in Trinidad and Tobago.
This has been a great discussion. Jason, as we are getting ready to wrap up, I would just like to give you an opportunity to give some final words of advice to persons out there who may be creators and may have concerns about their intellectual property. I'd just like you to give them some final words of advice, some final key points to keep in mind.
I think if anybody is embarking on any sort of creative venture, they should conduct an intellectual property audit of all the potential aspects of intellectual property that they are likely to encounter or to use in the course of that venture, and seek advice in terms of protection, because you have the peace of mind, for example, with a trademark, with an industrial design, with a patent, for example, of having registration. The registration certificate gives you a comfort of protection. Copyright, on the other hand, exists by virtue of creation. And very often, copyright disputes only arise when there is actually an infringement. So it's not something that you immediately foresee. Also, ensure that if you are embarking on a creative venture, that you are not infringing on anybody's copyrights, on anybody's trademarks. So in terms of creative assets that are available online, you can't just go on Google and search for an image or search for a video or search for sound and insert it into your creative venture. There are websites that provide licensed versions of these types of works, and you in turn can create works that you can license to other people for this same in the same way. All right, so ensure that what you are using in your own creative work does not violate anybody else's intellectual property, and of course, obtain legal advice if you are in doubt.
Thank you so much for that, Jason. Final words to you, Leonardo.
Well, I mean, it was a very interesting conversation, and I think myself, I would have learned so much as it pertains to intellectual property and the branches that could, come out of this broad term. And I am very, very happy that we would have had Jason on our program today, an expert, somebody who is very experienced in this field, so that to give, some solid advice as it pertains to how persons can protect their work, how they can go about protecting their work as well. And then, some of the homework that should be done before they can actually begin that creative process. And I think within the Trinidad context, it's going to be a well-received program today because, we are very creative people. And I'm very, very happy that we would have had this program here today. And we just want to really thank Jason for his time, his wealth of knowledge. And again, thank you very much today.
My pleasure.
Indeed. Thank you so much, Jason. So, folks, this has brought us to the end of another episode of the Legal Corner podcast series. Remember to check us out on social media. We are also on Patreon if you are interested in supporting our work. Bye for now, and we look forward to hearing from you.
Thank you for listening to the Legal Corner podcast series. For more information, please visit us at our Facebook or Instagram pages or send your comments to thelegalcornerpodcast@gmail.com. We look forward to hearing from you.